everybody, welcome. I'm Marissa Fallon, the Senior Director of Advocacy here at Defending Education. We want to update you about an important new ruling that recently came out of Ohio. A federal court decision just said that students do not have to use the preferred pronouns of other students if it violates their beliefs. And here at Defending Ed, we were so proud to stand with parents and students to make that happen. This is a huge victory for parents and for the First Amendment. We appreciate the parents of Olentangy, Ohio, for their involvement, which made this case possible. And I'm so excited to talk to you all a little bit more about this case and what it means going forward. So here to help me break it all down is Defending Ed's incredible Vice President and Legal Fellow, Sarah Parshall Perry. Sarah, thanks for joining us.
Thanks for having me, Marissa.
So Sarah, let's pick your legal brain. Can you explain to us what this case was all about?
Sure. So in 2023, we sued the Olentangy Local School District in Ohio over their unconstitutional harassment policies and their code of conduct, both of which violated the students' First Amendment rights by compelling students to use preferred pronouns to affirm the gender identity of their peers, even if doing so would violate their sincerely held religious beliefs, personal beliefs, moral beliefs. And if students failed to comply with this policy, they could actually face punishment ranging from no contact orders to suspension or expulsion. So this is like the 800-pound gorilla when you're thinking about the power of a school to expel a student for failing to use so-called preferred pronouns. According to the school district, misgendering was a form of prohibited speech because transgender students are a so-called protected class, and as a result, misgendering them would subject those students who refused to go along with preferred pronouns to these formal disciplinary policies. What's worse is that this disciplinary policy, this anti-harassment policy, followed students on their private devices off campus as well when they went back into their parents' homes. And at that point, the school is no longer in a position called in loco parentis, which is just fancy Latin for in the place of a parent. During the course of a school day, a school's role over a child is sort of custodial and tutelary. In other words, they have temporary custody of children with the explicit understanding that they will provide instruction to those children for a limited period of time, but it ends at the school day's termination. Unfortunately, this policy didn't end at the school day's termination. It followed the kids home on their personal devices. And so we brought challenges, not just on the First Amendment, but on the 14th Amendment, because those parents' rights to direct their children's upbringing and their communications had also been infringed.
Thank you so much for that explanation. Can you tell us what was the outcome? How did the court rule? And then let's start as close as possible to the case, which is in the Olentangy district. What does this ruling mean for families and students in that district?
Yeah, so during the course of the litigation, the school district actually attempted to moot the case. Again, just another fancy legal term for kick the case out of court, to say it's no longer a live case or controversy by adjusting some of the policies slightly to basically evade accountability, right? So they said, oh, we've changed our policies, we've amended our ways, that's not going to be a problem anymore. It amended its anti-harassment guidelines in September of 2024 to eliminate speech that might cause discomfort or humiliation or amount to teasing from the definition of what it determined to be bullying, and also revised its cell phone policy to clarify that the policy did not follow children home, and it was no longer designed to infringe on First Amendment free speech rights. Well, we argued that the case was still very much live, that these children had already been muzzled. They had self-censored to be quiet. And we achieved a loss originally in the Sixth Circuit on a 3-judge panel. But remember that on these appellate courts, there are multiple judges. And in the case of the Sixth Circuit, which is based in Ohio, there are actually 17 judges. And so we requested a rehearing en banc, which means in front of the whole court. That was held in March of last year, so about 10 months ago. And we had pretty good sensibilities after those oral arguments that we were going to achieve a victory, but it took a very, very long time for us to finally get the outcome. And that was on November 6th of last year, prior to Thanksgiving. We finally secured a victory, and by a vote of 10-7. The judges issued a tremendous victory, and one that we consider the most important free speech case in a generation, since a case called Tinker versus Des Moines in the 1960s. And if anybody remembers the Tinker case from high school, if you might have been studying civics or history, that was the case of the black armbands to protest the Vietnam War in 1965. Those students were originally expelled, and it was the reasoned determination of the Supreme Court then that the children had not lost their First Amendment rights once they had crossed over the schoolhouse threshold. In very much the same way, the Sixth Circuit ruled very similarly for our individual parents and their children on November 6th, saying that, again, a school cannot prescribe what is orthodox in matters that are controversial. It can't pick a side and require parents and children to toe the line, nor can it censor unfavorable or unpopular viewpoints. So we are incredibly heartened by this decision. It was a wonderful outcome, and we're looking forward to taking this victory and hoping to replicate it within districts and appellate circuits across the country. Marissa, you asked specifically about what this means. What this means now for all of the schools within the Sixth Circuit, and that is quite a number of them. The Sixth Circuit encompasses quite a number of states. So we're looking at states everywhere from Tennessee to Ohio to Kentucky. These particularly are states that now will have to abide by this ruling and make sure that students who express uncomfortable or disfavored perspectives on gender identity don't have to be muzzled, and they don't have to be forced to use preferred pronouns or express a message with which they disagree.
Okay, so just to drill down, so all of our parents listening know exactly what we are talking about and how this is going to be applied in the school. This ruling means that students in this district and in this circuit, they do not have to use a preferred pronoun of another student if they don't feel comfortable with that. So if a boy does not want to refer to a biological female as a boy, they don't have to. Is that how this is going to play out in real time in the school districts across the area where this case has been decided?
That's it. And the states in the Sixth Circuit, just for anybody who's listening and is living in any of these areas, are Kentucky, Michigan, Ohio, and Tennessee. So these are parents. If you're listening, if you're watching, if you're from any one of those states, you've got the opportunity now to go to your principals, your superintendents, your teachers, your school administrators, and say, there was just a brand new decision from the Sixth Circuit Court of Appeals, which is relevant to this jurisdiction, saying that my student does not have to use mandatory preferred pronouns.
So this is really incredible. You're so right. Like, this is such a huge decision, and it kind of touches on a few things that we always talk with our parents about. Number one is the importance of persistence, because this case has been going on for quite some time, and it did take a lot of twists and turns, right? Like, it wasn't a straight shot to success. So I would just tell all of our parents who are listening out there, stay engaged, stay involved, keep pushing for what you believe is right, because we've got a wonderful outcome like this, and hopefully we'll see more and more of these, but you do have to stay engaged and you have to keep your foot on the gas, if you will. And the second thing that I wanted to ask you about, Sarah, is this is an amazing ruling for the people in this circuit, right? All the states that you mentioned. If I'm a parent and I'm in a different state, if I'm in Massachusetts or, a different New England state or somewhere on the West Coast, how is this decision going to benefit me, or how can it be applied in my advocacy at my school about what my child might be experiencing or being compelled to say?
So while a Sixth Circuit opinion will have no bearing directly on California law, what it does is provide any potential judicial claim. So in other words, if a challenge gets to federal court, it actually provides an opportunity to essentially draw the court's attention to a good decision from another circuit and say, there are now a number of federal circuits who are sifting and weighing and saying, there is a very robust series of cases, not just from the Supreme Court, but now in the appellate circuits that are closer to these individual states that indicate students have free speech rights. This is a really important case. And while it won't have direct bearing on how the judges may rule out in the Ninth Circuit, which oversees California, it is something that they will have to take under consideration if a savvy lawyer brings it to the court's attention. And we know that many will. That was precisely one of the reasons, among very many, not just to enhance the rights of our parents and their children, but also to provide good case law for other good attorneys and circuits so that they too can challenge unconstitutional speech policies in their children's schools and districts.
So is that what when people talk about setting good precedent, is that what you're talking about? And that's what the main, a big benefit of this is, as you said, now this case can be cited by people in other districts who might be struggling with the same issue.
Absolutely. That has a huge impact on what we do in our legal policy shop here at Defending Education. We take cases that we think are going to make good law and that we think that we can win based on particular fact patterns or jurisdictions or the judicial composition of the actual bench, judges that we know are inclined to find for us on good constitutional and civil rights challenges. That is what we do. And we love to say that we've got a winning track record in doing it.
So one thing that we always love to advise our parents about is, okay, now that you've heard this, now that you've heard about this decision, what can you do if this is an issue of concern for you? So one thing we always recommend is to band together with other like-minded parents, find other parents in your district. If you're experiencing this issue or this policy, talk to other parents in your district, see if you can get a group of parents to go and speak to somebody in your administration. Form parent groups. I mean, this case originally started out of a parent group that we started working with back in 2021, if you can believe it. And they were very persistent and they were very unified. And so that really made things much easier going forward. So I would certainly recommend that parents do that. You can always reach out to us. We're happy to help connect you with other parents. What other recommendation would you have if this policy is being enacted? I mean, if this policy is still being enacted in one of these states, what would be your first step that you would recommend that parents would do as far as dealing with their school administration?
First, I would go to DefendingEd.org, our website, and I would search for our press release and the entirety of the judge's opinion, which we uploaded on November 7th of last year. Defending Ed victorious, an Ohio compelled speech case. So that would be something where you get sort of some talking points on the case itself and the actual copy of the judicial opinion, so you don't have to search all over the web. And I would hand deliver it to the principal of your particular child's school and say, there is precedent here for us to be able to say we are not going to violate our sincerely held beliefs on things like gender identity by forcing us to express messages we don't agree with. Not only does the Supreme Court agree with us, the Sixth Circuit agrees as well. And to avoid future litigation might be a good idea for you to toe the line on this.
That's amazing advice. Thank you so much. That's so empowering for our parents, Sarah. And if your school or your district has this policy in place that punishes students for not wanting to use another student's preferred pronoun, we want to hear from you. As Sarah mentioned, go to DefendingEd.org. You can send us a message at info@DefendingEd.org, and we're here to help and support you as you navigate potentially this policy in your school district. As always, please be aware of what is going on in your kid's school and ask questions. If you don't understand a policy, reach out to your school administration, reach out to your teacher, and ask them to explain that policy to you or that position to you. If you find something concerning, let us know at defendinged.org. Please share this video with a friend and tag us. Sarah, thank you so much for your amazing insight and for breaking it all down for our wonderful parents. Thank you so much for joining us, everyone. We'll see you next time.